If the other parent is lying in your Florida family law case, here's what you need to understand right now. Florida judges don't punish bad personalities. They punish proven dishonesty with real legal consequences. False financial affidavits, fabricated abuse allegations, conveniently forgotten text messages. In Florida, those aren't just frustrating. They can cost the other side custody, money, and credibility if handled correctly. Today, I'm going to show you exactly how Florida law deals with a dishonest co-parent and how we legally expose it. Segment 1. Lying versus legal credibility in Florida. The first mistake people make is assuming that if the judge hears two different stories, someone automatically gets punished for lying. That's not how Florida law works. Florida courts distinguish between conflicting testimony and provable dishonesty. Judges are the sole arbiters of credibility. That principle was reaffirmed in Lazaro Lau versus Gonzalez. The trial court decides who is believable and how much weight the evidence carries. But believing one witness over another is not enough to establish perjury. As clarified in Emanuel versus State, a judge cannot simply punish a witness because their testimony conflicts with someone else's. That's where impeachment comes in. Segment 2. Impeachment: How Florida Courts Expose Lies. Under Florida Statute Section 90.608, we are allowed to attack a witness's credibility using prior inconsistent statements. That means if a co-parent says one thing on the stand and something very different in a text message, email, financial document, or sworn pleading, we don't argue. We impeach. And strategically, impeachment is most effective when it's not chronological. When a dishonest witness is forced to jump between events, documents, and sworn statements, their story collapses under its own weight. Florida judges notice that. Segment 3. The most dangerous lie, the financial affidavit. The most serious lie in a Florida divorce or paternity case is almost always the financial affidavit. Under Florida Family Law Rule of Procedure 12.285, financial affidavits are mandatory, and lying on one is not forgiven, ever. Under Rule 12.540B, there is no time limit to set aside a judgment obtained through a fraudulent financial affidavit. In Mason versus Mason, a final judgment was reopened 11 years later because assets were concealed. And this isn't just civil exposure. Filing a false financial affidavit can lead to indirect criminal contempt. In Haesler versus State, the court upheld jail time for intentionally omitting income and made it clear that the amount hidden didn't matter. The intent to deceive did. Segment 4. False abuse allegations, when they backfire. False allegations of domestic violence or child abuse are some of the most damaging lies in family court, and Florida law addresses them directly. Under Florida Statute Section 61.133M, courts must consider whether a parent knowingly provided false information regarding abuse when determining the best interests of the child. In plain English, if a parent lies about abuse, that lie can be used against them in custody determinations. And there are financial consequences too. Under Florida Statute Section 57.1058, if a domestic violence injunction is based on knowingly false allegations, the court may award attorney's fees. And the burden of proof is clear and convincing evidence. The Florida Supreme Court confirmed this in Lopez versus Hall. False allegations are not protected. They are sanctionable. Segment 5. Texts, emails, and receipts. What Florida actually allows. Having evidence isn't enough. In Florida, evidence must be admissible. Under Florida Statute Section 90.901, electronic evidence must be authenticated. You can't just say, "I got this text." As explained in Walker versus Harley Anderson, courts look for distinctive characteristics: content, timing, internal references. things that tie the message directly to the sender. When done correctly, electronic evidence becomes one of the most powerful impeachment tools in Florida family court. Segment 6. Making them pay. Sanctions and attorneys' fees. Florida courts do not allow parties to profit from dishonesty. Beyond standard fee awards under Section 61.16, courts have inherent authority to sanction bad faith litigation. This is known as the inequitable conduct doctrine established in Moakley v. Smallwood. And under Rosen v. Rosen, courts may consider whether a party's conduct unnecessarily increased litigation costs. If a co-parent's lies force repeated hearings, motions, or discovery, Florida courts can shift those costs directly to them, regardless of financial need. In Florida, dishonesty in family court is not just bad behavior. It is a legal liability. Lies can reopen judgments. Lies can cost custody. Lies can result in sanctions, attorney's fees, and even jail time. But only if they are handled correctly. If you are dealing with a dishonest co-parent, do not try to fight this emotionally or informally. You need a Florida legal strategy that is precise, documented, and enforceable. Visit nestlaw.com to schedule a confidential consultation with our firm. We know how Florida courts work, and we know how to expose dishonesty the right way.